Thank you for joining us for another episode of Judge for Yourself. Land reform continues to be a controversial, motive if you wish, topic in South Africa. This time academics have raised concerns about new initiatives. They say government is looking to speedily approve a new land restitution bill in order to curry favour with chiefs ahead of next year's election. The Restitution of Land Rights Amendment Bill empowers government to reopen land claims until 2018. It does appear that the current version of the bill might make it impossible for communal property associations to own redistributed land, paving the way for traditional leaders to claim the land on behalf of communities. The Centre for Law and Society says this will further disenfranchise the poor. To discuss this particular controversial issue, we are joined in our Johannesburg studio by Dr. Masenjana Sibandze from the House of Traditional Leaders, Thami Mdonstwa, Deputy Land Claims Commissioner from the Department of Rural Development and Land Reform, and in Cape Town we have Nolundi Luwaya from the Centre for Law and Society. But before we begin, I wanted to play you this clip from Aninka Claessens, who articulates certain concerns about the bill to which I've already made reference.
Forced removals were a mechanism used to take over 3.5 million black people from so-called black spots to areas bordering the Bantustans, so to enlarge the area of chiefly power. Now, instead of those people that were removed, who bore the brunts of the Land Act and of forced removals, getting ownership of the land, ownership and control will go to the chiefs, who were in some instances complicit in the forced removals. So it's a very, very serious reversal of the policy of restitution. And it's deeply cynical that government is using restitution, which was designed to undo the Bantustans and forced removals, as a means of actually bolstering chiefly power.
Well, that's a fairly controversial proposition, particularly since you, the people, are drafting the bill. How do you respond to that?
Judge, in the Restitution of Land Rights Act, as it currently stands, there's no reference to traditional leadership or traditional communities. And the same applies to the Restitution of Land Rights Amendment Bill. The Restitution Act requires that when a claim is settled by the court or by the Minister of Rural Development and Land Reform, where the claimant is a community, that the land must be given back to that community, and the land must be held in a manner that is fair and democratic, and the institutions that are going to be responsible for the land must be accountable to the people. What academics have done is to confuse proposals that are currently being made on communal tenure. That is where we start to look into the whole issue of ownership of land on communal tenure.
Why is it that I understand that your department has refused to transfer title to at least 34 communal property associations where restitution awards and signed agreements are now in place?
There is one case that is mostly referred to, and that is a case of Kata community in the Eastern Cape. The Kata community.
That's not the only one, but you can talk about it.
Yes, we'll discuss the Kata. There is a village that is inhabited by people. They were awarded land through an agreement that was signed by the minister in the early 2000s. Now, since 2009, the mandate of our department has been broadened to include not just land reform, but rural development as well. So we have had to look into a broader basket of issues as compared to what we were doing in the early 2000s. But since there was already an agreement that was signed as part of the settlement of a court process, the department is now in the process of transferring that land. You will recall that...
So you're saying that you're not objecting to transfer land to communal property association?
We are not.
All right, we'll come back to what Lundi has to say. Can I just ask you, what's your response?
I think there is an over-exaggeration. As my colleague has rightfully said, the Restitution Act restores land to individuals or group of people, be they communities and so forth. And the restoration of land is in terms of a variety of tenure options, depending on what people want. People may choose a CPA. If that's what they want, so be it. people may choose to live under the traditional tenure system.
Who should have the choice?
It is the people.
Not the traditional leaders.
It has never been.
All right, well, let me ask, Nolundi, I mean, your colleague, Ninka Claassen, has already made her position fairly clear in a clip that I've just played. What do you say to the two guests in Johannesburg?
Dennis, my response would be to say that I think that it's unrealistic to separate out the Restitution Amendment Bill from the communal land tenure policy that's currently circulating. The concern is that although restitution indeed does not quite link up with communal land, the concern is that people had to form CPAs in order for them to get land back through the restitution process. This year alone, the Minister of Rural Development, Minister Nkwinti, has made statements expressing the fact that they feel that the idea of communal property associations was possibly a mistake. The sentiments that have been expressed by government have been that having communal areas within communal areas is just simply not tenable. And so what that means is that the restitution process is being opened, but the vehicle that people were given to make these community claims for restitution is actually been taken away.
Are you saying they don't have a choice?
Policy,
are you saying they're not going to have a choice?
It would seem that they're not going to have a choice. The problem is that they won't have this CPA vehicle anymore because government is speaking about principally discouraging the formation of new CPAs. And so the question becomes, what vehicle will people have to make claims for land when they're making the claim as a community if they don't have this CPA vehicle anymore?
Okay.
And so our concern is that it opens the way for traditional leaders to make claims on behalf of the community. And so what that does really is that it opens up sort of a real pot of potential abuses and potentially having people not be able to make community claims because the CPA vehicle is being principally discouraged.
I'm going to deal with this. I can see nodding and not nodding from my guests in Johannesburg, but I have to take a break first.
News that moves. ENCA.com.